All right, thank you everyone for coming. I think you all know, I'm Bryn Smith. We have precious little time, so we're going to jump right in. This is a press conference. It's not a meeting of council, so there's a little bit different of a procedure, so I'm going to explain that. But first, this is Liz Bradbury, our expert, who has graciously come up here to work with us and answer questions. She's here to answer those questions, and you can certainly ask questions to the members of council who are here, but we may defer to Liz as she is helping us with this and has graciously offered to train our Human Rights Commission. And we do want to answer your questions. That's why we're here. But I'm going to ask everyone to be respectful. Please keep your questions brief. And please do not ask the same question over and over. Everyone in the rotunda can hear. Everyone here can hear, so we know if a question has been asked and answered. And I would like to remind everyone, this is not public comment. This is question and answer. So the questions must be specific to these ordinances. We're keeping it to facts here. So the procedure is that everyone will have 2 minutes for your question, and whomever is answering will answer for as long as they need to, and maybe even one or two of us may answer. And if you have a follow-up question, we'll give you 30 seconds for your follow-up, and then, again, whomever will answer for as long as they need to. But after everyone has a turn, if you still have lots of questions, or a question that you want to have asked hasn't been answered, or hasn't been asked, you can come back. Just please fill out another slip so we know that you have another question, but only after everyone has had a turn. Okay? But please don't bogart the podium, is what we're trying to say. I hope some of you got that. I know that people here have very strong opinions, both positive and negative, and that's okay. But I'm going to ask you to please not to talk to your neighbor or shout out of turn so that people cannot hear. So here's the procedure that is going to run tonight along with the timing, because we do expect there was a discrepancy in the reporting at the time of the start of the meeting. That's why we started at 6:15 instead of 6:30, so there may be more people coming. And if there are more people coming and we cannot fit everyone in the council room, we want to give everyone equal time and equal opportunity to have their question answered face to face. So we'll be possibly, if we have spillover, we might be moving people out in groups. So you're group one, all of you will get a turn if you have a question. At the end of all the questions in group one, we will ask you to please leave, to sit outside, and we'll bring the people outside who have questions. If we don't have a room, we'll bring them in, and they will ask their questions, and they'll have FaceTime with our expert and counsel, just like you did. And we all want everyone to participate equally. So if you are not agreeable to this, I want to make this very clear. If you are not agreeable to these procedures, it might be better if you leave now. This question and answer session is about facts and is about civil public discourse. So I'd like to very briefly introduce Liz Bradbury. She is the founding chair of the Lehigh County Human Rights Commission, and she has very graciously offered to train us for free. She has trained at least 5 other counties. She has a lot of experience with this that she will tell you about herself. She is the original drafter of this law, and it took 4 years to write in whole. She has been working in human relations law in Pennsylvania since 1998, right? So take it away, Liz.
I'm Liz Bradbury, and I'm the chair of the Lehigh County Human Relations Commission. The Lehigh County Human Relations Commission ordinance was written by a diverse human relations council appointed by county legislators. I led the Human Relations Council to write the ordinance, and I'm the primary author of it. It took 3.5 years to write and was carefully reviewed by county solicitors. It is supported by and conforms to Pennsylvania state and federal law. The Lehigh County ordinance is the basis for Allentown's ordinance, which was passed in 2005, Chester County's ordinance passed in 2025, 2025, Chester County passed in 2025. Delaware County passed in 2025. Northampton County's ordinance passed in 2026. It's exactly the same as Luzerne County's ordinance that was passed here in June. I helped with the passages of each of these places, and all of these ordinances are about the same as Lehigh County's ordinance language, including the Lehigh County, or the Luzerne County ordinance, which is virtually the same as the Lehigh County ordinance. I've run the Lehigh County Human Relations Commission since its inception 2 years ago as commission chair and primary investigator. There are 12 other commissioners working with me on the commission. Before working on the Lehigh County ordinance for 4 years and as a leader of that commission for 2 years after that, I also served on the Allentown Human Relations Commission for 15 years as the primary investigator, commission trainer, and as chair. And that was from 1998 to 2014. I've successfully helped to write, craft, and pass 23 civil rights laws in various parts of Pennsylvania. So I can answer any of your questions based on practical application and many years of experience. First, I want to explain 3 important things. The purpose in the United States of Human Relations Commissions. Pennsylvania's initial passage of its Human Rights Act was in 1955. Philadelphia's was in 1948 with a commission in 1951. The city of Allentown passed in 1963. The United States passed the National Civil Rights Act in 1964. When these early civil rights protections were passed into law, governments created human relations commissions to help resolve discrimination cases and to erase and ease racial tensions. But also, some legislators imagined that because of granting of civil rights to minorities in these laws, municipal courts, where judges and bailiffs and court security and the buildings themselves are all paid by taxpayer money, they would be overrun not only with real cases of discrimination, but that every minority member who was not hired or promoted or who was denied housing would immediately file discrimination lawsuits that may be unfounded. To create a relatively free way to lessen the pressure on the courts, every one of the 50 United States passed legislation to create volunteer state human relations commissions, and that state legislation in each state included provisions for cities and towns to create their own volunteer human relations commissions. These commissions provide an ability for the volunteer commissioners to determine whether discrimination had really taken place, usually resolving the issue before it had to go to the courts and thereby saving taxpayers significant money. Pennsylvania was one of the first states to establish a Human Relations Act, and that passed in 1955. And within it, in Section 12.1, the Act provides for the power of every municipality in Pennsylvania, county, town, city, whether it's home rule or not, the right to create its own human relations ordinance and commission, which all of its people must follow. These relieve tension, relieve instances of unfairness, expedite resolutions, and save taxpayer money. That is what you are doing in Luzerne County with your ordinance for the good of the people. Pennsylvania has 82 municipalities that have human relations ordinances and commissions, including 8 counties. The earliest one was passed in 1948. The most recent one, before you, was passed in March of this year. So let me say this. This is the beginning of the ordinance that you have. If in case you haven't read it, nothing in this ordinance shall be construed as supporting or advocating any particular doctrine, position, point of view, or religious view. To the contrary, it is the intention of this ordinance that all persons are treated fairly and equally, and it is the express intent of this ordinance to guarantee fair and equal treatment under the law to all people. Now, let's right up front, that's my first thing that I want to say. Second thing I want to do is talk about the money. Running volunteer human relations commissions is very inexpensive, certainly much less expensive than taxpayers having to pay officers of the court like judges. Lehigh County's Human Relations Commission's budget for our first year was $500. At the end of the year, we had $566. I don't know how that happened, but we weren't spending any money, and apparently we were making money. I don't know how that happened. But we didn't spend any money. Chester County's budget also is $500. They are running their commission now. Allentown, which is running their commission since 1963, is zero. They have no budget for their funding. It's a volunteer commission. Delaware County's is $3,000. Northampton County's is $5,000. And apparently Luzerne County's budget is $1,500. At least that is what I read in the paper. Remember that Luzerne County's entire budget per year is over $340 million, so $1,500 is negligible. I can tell you from expertise that you will not need more money than that in the Human Relations Commission budget. Remember that the commissioners are volunteer, and they will do the investigations of the complainant's evidence of discrimination, and I will train them how to do this, and I will train them for free. So your concerns about the basic cost of this commission can be dispelled. There, that's the second thing I want to say. Now, you can forget about liability and litigation. If anyone has tried to frighten you with that, that is a lie. Just like every other U.S. state's commissions and other parts of government, all of them are covered by statutory immunity. Any current or former elected official should know that. The law in Pennsylvania is called the Pennsylvania Political Subdivision Tort Claims Act. It was signed into law in Harrisburg in 1978. It protects government officials and their entities, including human relations commissions, by making them immune from lawsuits, and this has always been the case in the United States, this just happens to be the latest law, from lawsuits based on their actions. Every part of the government has statutory immunity. You can't sue a judge because you don't like their decision. You can't sue a police officer for giving you a ticket. You can't sue a legislator for creating and passing a law just because you don't like it. You can't sue a commission because you don't like that you were found by the commission to have discriminated unfairly against someone. Even if the commission has made a mistake, you cannot sue them because they all have statutory immunity. There is no need to have more insurance because a person might bring a lawsuit against the commission because they thought the commission did something wrong, because the commission is immune to that kind of suit. So they could file a suit, but when they brought it in, they'd have to pay to file the suit. They would go into the court, and the court would say, you can't file this, and then they'd have to pay the court costs. That's the end. You cannot file a suit in those circumstances. There is no danger of litigation or liability. Pennsylvania, the name of this is the Pennsylvania Political Subdivision Tort Claims Act. You can read it by Googling it. There is no need to increase insurance. So that's not going to cost you anything, and if somebody told you differently to get you to sign a petition to overturn the ordinance, they may have done this intentionally, not telling you the truth, just to get you to sign. Cost of the, okay, so that's the three things that I wanted to say. I have some other circumstances of questions, but if there are questions, let's go ahead and answer them.
So our first question is, no surprise, the inimitable Walter Griffith. Come on up. You have 2 minutes for your first set of questions.
Okay.
Oh, please, yeah, okay, thank you. Turn it on.
Well, that whole thing about public officials not being sued is nonsense. I was sued and the county paid. So
Okay.
you could just scratch that one right off. I'm living proof of that. So you guys all are subject to be a lawsuit, regardless of what she just told you.
Let's get yourself Facebook.
It cost the county $15,000, by the way. My first question, and I'll read my questions for my 2 minutes, and then I'll wait for the answer, and then I'll give a 30-second rebuttal. So how many complaints are currently in Harrisburg more than 6 months for Luzerne County that are sitting in Harrisburg? And I do know the answer to that, so I hope I get the right answer. How many complaints are currently sitting there? Because I think the idea of this ordinance was to expedite complaints that are sitting in Harrisburg for a long, long time and people aren't getting relief. So I'd really like to know how many complaints are currently sitting there. And I do understand that the commission is not going to cost the county more than $1,500. It's the lawsuits that are going to cost the county the money. When when they sue the county's going to have to pay. Not the commission, the county. So we need to be clear on where that concern comes from. I know the commission is not the cost. Why is the judicial branch exempt from this ordinance? In all the other ordinances that Lehigh County's drafted in all the other counties, the judicial branch is not exempt from their ordinance. However, Luzerne's is. I want to know why that was put in the ordinance. And that's in section 7 or 6. I wrote it down here somewhere. Let me see where it is. It's in section 7, I believe. They added that to that ordinance, which is not one that you drafted, Liz. That is a different section. So they are not the same. All the counties are not the same.
No, they're not all.
All the other counties have the commission included in their ordinance. Luzerne County's does not. Why is that? All the other counties, if they used yours as a mirror, why did not include that?
Walter, that's your time. Walter, that's your time for now.
Okay. I have more, but I'll come back to my others. So I'll wait for my answer.
So the first question was, how many actual cases are in Harrisburg? So let me make a comment about Luzerne and people in general, filing cases. In Harrisburg, 85% of the cases that are filed are found to be not jurisdictional, but it takes them months and months and months to even look at a case. So if there is a large number of cases, and it could be, I don't know, 80, something like that, could be 5, could be whatever number, but the likelihood of any of those cases to actually be jurisdictional in something that the Harrisburg or the Pennsylvania Human Relations Commission is going to follow up on is very small. 85% are not jurisdictional, and that means they're not discrimination cases, or they didn't happen in the place where they said, or they happened more than 180 days ago, or the person couldn't name the protected class that they were discriminated against. That happens all the time, and it happens frequently in every Human Relations Commission. So what happens is they can have these cases that are in Harrisburg sort of boiling over, and why doesn't anybody deal with these? But one of the problems is they're not jurisdictional, and if they had been in Luzerne County, they could have been like I did on the last case that we got in Lehigh County, and it pretty serious case, and I looked at it, I got it, on the first day that I got it, I opened the complaint form. It was sent to me through email. I opened the complaint form. I called the complainant. I said, where did this happen? She said, Shillington. I said, that's in Wilkes County. It's not in Lehigh County. I'm really sorry, but I can't help you with this. And then I said, I will send you a letter dismissing the complaint. It took an hour to do that. If that person had filed with the state, it would have taken 2 years for that to end. Even just for the person to look at it and say it wasn't in the right place.
But my
Will
question
take 3
was, how many
months.
complaints do they have in Harrisburg?
Well, I don't know.
Currently, they're waiting.
Well, what I'm saying is that they're waiting because you don't have a local
They don't have any
ordinance.
waiting for Luzerne County. That's my question.
Right. They don't have any?
No.
Oh, well, maybe people are uncomfortable about filing.
Oh, but that was the reason for the ordinance.
Okay.
Okay, all right. My
Maybe they didn't want to go to Harrisburg.
Sorry to interrupt you. Go ahead and answer my next question.
Okay, next question is, what was it again?
My next question was why was
that
the
me?
judicial branch exempt from this ordinance?
I didn't write that part, so I don't know.
What we did.
Huh?
It's your ordinance.
No, I didn't write it. I don't know. I wrote the basis of the
You said it was your
ordinance.
copy of your ordinance.
Okay, I
They
didn't
used
say.
your copy of your
I
ordinance.
used all of those ordinances for all of those
So
communities.
then
Use
I'll
this
ask
as
the
the
chairman of the
basis.
council, who added that to the ordinance? And why was that not done, something done by council?
I'm
Can't
not
answer that,
sure.
right?
Hey, hang on, Walter. I'm not sure to what you're referring.
There's a section in there that says the judicial branch is exempt. It's in section 6. 601, I believe it is. 602,
Am I
actually.
looking- wait.
602.
While she looks at that, we can talk about your next question. What was the next question?
That was the question, was how many complaints were there? And
Okay.
the litigation costs was the first question, was about the cost of litigation is the issue here. It isn't the cost of the commission, which is $1,500 for office supplies and all the other nonsense that they're going to need. It's the litigation. When somebody sues the county, and they win, we have to pay.
Well, if an individual is sued for something like slander or libel, an individual on the commission, if they make a slanderous remark, or they commit fraud, or they commit some kind of personal immoral act, then that's not action of the commission, that's an act of an individual. And the individual commissioners are certainly admonished to be appropriate and not say
But they're a
inappropriate
part of the
things.
county, and they're responsible. So if the commission gets sued, the county gets named as a party to the complaint, to the lawsuit. And the
Walter,
county has
I'm
to
giving
pay.
you a lot of leeway, so.
Pardon me?
I'm giving you a lot of leeway for now.
Right.
But there are other people who have questions.
Okay.
So
I appreciate the latitude, but if I can get an answer to who added that section to the chart, the ordinance.
I'm looking for the section that you're talking about, and I'm
602?
looking at six.
It says, "This ordinance shall not apply to the judicial branch of government or any entity where application would violate the separation of power under Pennsylvania Constitution." And when we just went through Kids for Cash in 2010, I would think that that would be a very bad thing to put in
That's
this
not in our
ordinance.
ordinance, I don't know why that's.
We were the biggest scandal in the
Okay,
Commonwealth.
we all know about Kids for Cash.
All right, so how did that
Walter?
get in here?
Please.
If I could just, I don't know how it got in there, and I don't know the exact reason. However, there are separation of powers, and county council can, as you know, cannot control the controller. County council cannot control the judiciary, and judiciary,
Right.
and county
Judges.
council cannot control the district attorney's office. So,
Or the executive branch?
a majority of council can control the executive branch, but aside from that, you know, I mean, these are questions that don't have anything to do with the actual carrying out of the ordinance or any of the more popular.
My point is
So
that
the
you guys, my point is
Walter, can I
my
answer?
point is you approved an ordinance and don't even know what's in
Can
it.
can I answer you?
Yes.
It got in there because of that. I had to read it again, I'm sorry. We cannot control the judiciary, so we have to exempt them.
But who put it in there?
I
It's not in
did.
anybody else's.
I
That
did.
language is not in anybody else's ordinance.
Well, that's because I know that we can't, and you should know that I know that we
Who put it in
can't.
there? Did you put it in there?
I did, but I've said to look at it again. But we can't control the judiciary, and
Can't
the
control the
point of,
executive branch either.
well, you know that a majority of us can. We're not here to argue about the charter. Come on.
No, you cannot.
I'm
There
gonna
is
ask you to
separate
sit down.
Hey, that applies. That language
Walter!
applies. That language applies.
Walter!
Yes,
Walter, I'm going to ask you to please leave the podium at this time.
Yeah, you're done now.
I'm sure you
Proceed
will.
with the
Absolutely, because I got
questions.
this where you wanted. Perfect.
Thank you, Walter, for
Sit.
your questions.
I'd like to add a couple more things. We cannot control the judiciary. We cannot control what cases they take.
You can't control
And the
yourself.
point of this was to stop the cases from going to the courts. Because a lot of times, people don't know that they're discriminating. And I'm sure Liz would eventually get to what we have seen with other counties that have this kind of ordinance. A lot of times, a complaint that actually makes it in front of the Human Relations Commission, which is not very often because of jurisdictional issues, oftentimes the person who is accused of discriminating says, I didn't realize I was doing that. I'll stop doing that. And that's it. People just don't know sometimes. So we don't want our courts clogged up with that kind of thing. So not only can we not control the judiciary, but also the point of it is to not clog up the courts or Harrisburg. That's why that was added. I would also like to point out that while Walter is correct that the county covered him, he was sued for slander, which was not one of his duties, covered by the insurance, or covered by immunity, I'm sorry, covered by statutory immunity. So that case that he's talking about is extremely different from what Liz is talking about. So that is absolutely incorrect. He did not state that fact. What I am stating is fact. That is the point of us being here. Thank you very much. Jerry Kaczynski.
Good evening, everyone. We the people want to know how much exactly this is going to cost us in tax dollars. And another thing, can you guarantee the $1,500 limit?
I think if it's in the budget, yeah, it's guaranteed. It's not going to cost any more. And I can tell you this, I've been running this commission in Lehigh County for 2 years. It hasn't cost a penny over our budget. And in fact, we didn't use any of our budget. This year, we used $250. Last year, we didn't use any of our budget. That's it. I mean, there's no cost to this. This is a volunteer commission. And so the fear of having this huge amount, remember 82 municipalities in the state of Pennsylvania already have human relations commissions. Most of them have no budgets at all. None of them have ever been sued or for liability or litigation ever since 1948 when these commissions have been running. They haven't been sued. They haven't been a burden to the taxpayer. They've actually saved taxpayers money.
Okay, but if it's gonna be $1,500 per year, can you guarantee that it's only gonna be $1,500 a year? Say 3 years from now, jumps to 3,000 or 5,000 or 10,000?
I would answer that with, most of our authorities, boards, and commissions don't actually have a budget. The Arts Advisory Board doesn't have a budget. The Arena Authority doesn't, it hasn't a budget, but that's funded through the hotel tax. But 99% of our commissions don't have budgets to begin with. So we are doing this out of an abundance of caution, the 1,500, but we're hoping that this mirrors the rest of our commissions. Our opioid commission that unlocks the opioids trust money does not have a budget. The County Cares Commission has a very small budget, just in case it wants to do some kind of like work out in the community. But most of the authorities, boards, and commissions, like the authorities are allowed to have their own budgets. They're independent agencies. We don't fund them. But the boards and commissions don't generally have a budget.
Okay, but I'm saying, if it does go beyond that, where's this money gonna be coming from? Falling from the sky? I don't think so.
Mr. Kaczynski, that's your last question for now, okay?
Mhm.
So we're going to answer it, and then you're done.
Can I just answer this?
Yes,
Because
of course.
I really want to say that commissions across the state cost no money. They just don't cost anything. And if you keep thinking, well, there's going to be these mushrooming costs and stuff, there's not. I mean, Allentown has run its commission on a zero budget for the last 20 years. They don't have it. It's a volunteer commission. There's no cost to do that. And the process of investigating complaints and stuff is very simple. And so it's not going to cost people. And in fact, this kind of money, $1,500, which is probably not going to be used, to protect the rights of all these people, veterans, disabled people, single mothers, people with cancer, people with heart disease. Why would you not want to do that? And for that very small amount of money in a budget that has hundreds and hundreds of millions of dollars. I think this is a great use of the expense of this money.
Well, here in Luzerne County.
Mr. Kaczynski,
Thank you.
If you have another one, you can come up when everybody else is done. And Sheriff, I just wanted to note, if people are coming, if you could tell whoever's out there, if people are coming in, we just have a few more seats, and if you want to collect the slips, just make sure they're in order, so whoever got here first, and you can bring them up whenever. Thank you very much. Next, Corey Dunn. And I apologize, I forgot to ask to please state your municipality. Walter, I know you're from Trucksville, for the record, and Jerry is from 44 Shoemaker? Swartzville.
Corey Dunn, Hanover Township.
Thank you.
I have two questions, mainly. You answered a lot of them about financials. My biggest question I had from the beginning is, was there a fiscal risk assessment done before we started this? And you answered that very well. And you also brought up that even if the board is wrong, no one can do anything.
No, that's, okay. Okay, I want to answer that. If the board is wrong, if, for example, the Human Relations Commission finds and I can, first I want to outline the fact that the process is this. The complainant, the person who is complaining that they have been discriminated against, must bring solid, verifiable evidence to the commission. They have the burden of proof. They don't just come to the commission and say, I think I got discriminated against, could you figure that out? And then we'd send out a bunch of people who are like Sherlock Holmes to figure this out. Not at all. The commission says you must present to the investigators, the investigator is investigating the veracity of the evidence of discrimination. And they look at that discrimination and they say, wow, here's a letter from your employer who says you can't work here anymore because you're disabled. And it's a blatant instance of discrimination. So that person has given that. Now we go to the respondent, and the respondent says, yeah, I did that. Well, then we're done. If they say, I didn't send the letter, we say, can you prove you didn't send that letter? If they say, I sent the letter, but I don't think it was wrong, then the commission may find that the respondent is guilty of that discrimination, okay? And that's just the investigation process. It's the same circumstances if you have a codes board, a codes department, who says, we're gonna fine you because you were supposed to build this foundation this way and you just used cardboard. So we're gonna fine you. They don't have to have a judge to decide whether they get to fine it because they're empowered to do that. So now we're in the situation where the commission says, and they don't fine right away, they say we need to make the complainant whole. And if the respondent says, I don't think I'm guilty of this, they can go to, and the commission has found all the way through probable cause, and then maybe even a public hearing, which is very rare. I've never even seen a public hearing in 30 years. But if there's a public hearing and the respondent still says, I don't agree with this, then they can go to a judge in the Court of Common Pleas, which is free, and they just file in the Court of Common Pleas. And then the judge looks at the evidence, and if they really believe that the commission has misinterpreted the evidence because the respondent can explain that, then it's overturned. It's overturned.
Okay.
So you do have an absolute opportunity to overturn it. It's not a done deal.
And I just want to add something, just to be clear, and please tell me if I'm wrong, because we're all still learning, right? Life is learning, and we never stop learning. But the burden would be on the complainant.
Yeah.
That's how it works. So the complainant would have to prove it.
Yeah.
It's not just the respondent is trying to prove that they didn't do it, because if you know anything about logic, you can't prove a negative, right? You have to prove a positive. So the burden is on the complainant.
Yeah.
That's all.
And let me add to that for everybody. That means there are no instances of he said, she said, where the complainant said they did it and the respondent said they didn't do it, and it's even. Because if it's even, the complainant loses. They have to tip the scale in their favor. They have to demonstrate that they were discriminated against. And if they cannot prove that, if they don't have the evidence, just like on People's Court, if they can't prove that, they have the burden of proof, then the respondent is victorious and the complainant loses. Okay? Thank you.
The only other thing, have you ever dealt with anyone abusing the discrimination ordinances and laws?
Well, not successfully, but what happens frequently is somebody says, well, I was thrown out by my landlord. I mean, you know, let me say this. The Human Relations Commission in Lehigh County in 2 years has had about 8 complaints a year. And among those, 4 of them were found to be prima facie, which means on the face of it, it looks like discrimination. And 2 of those 4 were found that the complainant was discriminated against. The other ones were people saying, I don't think it's fair that my landlord discriminated against me by evicting me. And I say, what was the protected class? And they say, huh? And I say to them, well, were you discriminated against based on protected class? Well, it must have been that. Is there any other reason why you were evicted? Well, I hadn't paid my rent for 6 months. Well, that's the punchline. The investigator says, okay, thank you, click, dismissed. Because that's the investigator's job in the investigation, right up front, to look at the evidence that the complainant brings.
Thank you.
You're welcome. Thank you.
Thank you, Mr. Dunn. Beth Hartman? And while she gets to the podium, I also want to note, if you've been paying attention to the number of years these ordinances have existed and these human rights commissions have existed, we are not in any form of uncharted territory or uncharted waters here. We've seen a lot of this. We have a lot of examples. We have a lot of evidence that we have worked on and looked at. So this is not something that's brand new. We have experts in this field, obviously.
As,
Thank you, Beth.
sorry, Elizabeth Hardman, Hanover Township. As many know that follow me coming here, I'm for the ordinance. Not only for LGBT and that kind of stuff, but a year ago, my partner lost her job. And she's 65. And she lost her job because in 22 years, she never had a write-up, had anything. And a year ago, she was diagnosed with a kidney disease. So she didn't have scheduled breaks. She was a non-union.
Beth, I'm really sorry. This isn't public comment. Do you have a
It
question?
is a question, I'm
Okay.
sorry. And so what we did was we filed with the state. And it's been over a year, and we just got the letter that said we received your complaint. So I don't know.
So there is a complaint.
What, like how many we have there, like we can look into how many, that's my question, like how many do we really have there in different stages? Because we have ours there, trying to get rectification. Thank you.
So
Thank you.
I'd like to note, so there is one in Harrisburg.
you're good.
Would there be a mechanism for any complaints recognized already in Harrisburg that have been taken so long to come back to us?
I don't know that, if there was a possibility to I don't know. I mean, well, one way to do it, first of all, the complaint, the instance of discrimination has to have happened in less than 180 days. So if somebody has filed in Harrisburg and it's been there for a year, it's too late to file again.
The filing date wouldn't preserve the date?
No, no.
Okay.
No, this
Not
is
in
an
that
open
situation.
case, they say.
It's an open case for you,
It's been.
but I don't think you could file again in another jurisdiction.
No.
I think it's great that it's an open case, and I also think it's indicative of the fact that Harrisburg doesn't always have all of the information that they can share so readily. And I think that's really true. It's not that they're doing it on purpose, I think they're
65 is
overloaded.
a protected class, and
Yes.
she's a lesbian, that's a protected
Yes.
class.
Okay, great, thank you very
Thank you,
much.
Beth. Mary Ann Pottsville?
Good evening, and I'm from Hanover Township, and I'd like to look at section 101. Be it known to all that the county of Luzerne does hereby declare its intent to promote the rights and opportunities of all persons to participate in the social, cultural, recreational, and economic life of the county, and to assure equal opportunity for all persons concerning employment, housing, education, healthcare, and use of public accommodations without regard to actual or perceived race, ethnicity, color, religion, creed, national origin, or citizenship status. I want to stop right there. I just want to know if you are guaranteeing illegal residents the same rights of legal, law-abiding, tax-paying American citizens, many of whom have had multiple people in their families serve in the military to protect the rights of legal, law-abiding, tax-paying American citizens. And would such people take precedence over the rights of American citizens in housing and other institutions?
They would absolutely not. People who are illegally in this country are not protected by this ordinance.
Then why do you
Except-
say that?
Well, let me explain it then.
Sure.
And I think this is a question and answer, a quiz question. If you are in the United States and you are not a citizen, can you legally work in the United States? What do you need to be able to legally work?
Working paper.
And
Green card.
a green card. A green card. So if you're not a citizen, but you have a green card, you cannot be discriminated against if you are applying for a job that you are qualified to do.
But yet it states that you are the citizenship status.
Yes, your citizenship status, but also in the ordinance, and this is important for everybody to recognize, in the United States, it is illegal to hire somebody who is not legally authorized to work. And this comes under the Nationality and Citizenship section, it's the definition of nationality and citizenship. If you find that, that's a state and federal law, and it specifically talks about people who are legally in the United States, people who are permanent residents, people who have asylum status, and people who are allowed to be in the United States legally. But it does not protect people who are not legally in the United States, and it specifically says in the ordinance, there is nothing in this ordinance that will compel anyone to break the law. It is specifically in the ordinance. So no, anybody who is in the United States who is illegally here cannot rely on the ordinance to protect them from being arrested, for that matter. Now, one thing I do want to say is, lots of us in this room have been in other countries. You've traveled to other countries, Mexico or Canada or Europe or something like that. When you went into that, they didn't say, you can't come in here, we're going to arrest you because you're not a citizen. You're a tourist. And we have tourists in the United States all the time from other countries. And it's perfectly okay for them to be here. They just can't legally work here. Now, they might be able to legally rent an apartment if their tourist visa allowed them to be here long enough. And what the law says, all the way to the federal law that has to do with ethnic origin and the citizenship status, and this is a federal law, you can't discriminate against somebody just because they're not a citizen. But you absolutely can discriminate and are not compelled to break the law and hire somebody who is not legally authorized to work. And that is absolutely what the ordinance says and implies in every way.
Second question.
Yes.
Is that when you talk about this commission that's going to investigate the complaint,
Yes.
it's also been said that there will be a legal cap of $25,000 per year. Is that correct?
Who said
or
that?
not?
She said that.
Yeah.
It was in the Times Leader article.
Well, that was wrong.
Luzerne County, actually, the Bureau.
I don't think that's absolutely not.
That's not
The
correct.
council never said that?
No, that is very new information to me, ma'am. I've never.
Nobody said
that. That is
Okay,
incorrect.
so are you saying then that the commission makes the final judgment, that they do the investigating, there is no other person that it goes to or entity, any
No,
legal
that-
entity that does any research?
No, that's not exactly what happened. This is what happens, and I'll outline exactly how the complaint works. The complaint comes in. It comes in on a complaint form. The investigator investigates the evidence of the complainant.
The investigator is the 13-person commission.
One of the people on the commission, usually a person who has a little bit of experience doing this, not hard, and I'm going to train everybody, it's not tricky to do this.
And they do
Yep.
this voluntarily?
Yes.
Okay.
And every commission is a volunteer commission. Even the State Human Relations Commission is volunteers.
Okay,
So-
so then somebody put out some bad information.
Yes, they did, and they're doing that too.
$1,000 cap?
That's absolutely not
Exactly why we are having
And that's why we're
this
here.
discussion.
And we don't want people to think that this ordinance is tainted by those ways, by people telling you things that aren't true. But I can tell you that the process is that the commissioner, who is the investigator, looks at the complaint. They investigate the evidence of the complaint, and if they find that the evidence of the complaint is prima facie and compelling, then they will talk to they'll send it to the respondent, and if the respondent comes back and says, yeah, I discriminated against the person, then that's the end of the complaint, and then we find some kind of circumstance to make the mediation or something like that would allow the complainant to become whole, so that the case wouldn't go into the courts. It would be determined and resolved before it has to go to the courts, even though the respondent is saying, yes, I discriminated against the person. We're trying to stop that from happening.
So in Allentown or the areas that you have experience
Lehigh
with,
County.
do you have legal people on this commission? Who do you determine is on this commission? How do you determine who is on it?
Okay, so you've got 13 people on the commission. I could say the most recent commission that was seated in Chester County, they had 2 lawyers and a mediator, and they also had a bunch of ministers, and they had some teachers, and they had some moms, and they had some people who are concerned about civil rights stuff, and had some social workers. And each one of them was able to look at the complaint and see whether or not there was bona fide evidence or not. Because here's an example of evidence. And I saw somebody come in with an emotional support animal. We had a case where a person had an emotional support animal which was supported by federal, state, and county law, and got a letter from their landlord who said, you're going to be evicted in 10 days unless you get rid of the dog. And the person said, I sent you all the documentation, all the information about why this is supported by state and federal law. I don't understand. And the respondent sent an email back, this is all in writing, sent the email back and said, I don't care what you say, you have to get rid of the dog or you're out. Well, this is blatant pieces of strong evidence of discrimination, and the complainant was able to present that to the commission. And so the commission looks at that and comes back to the respondent. We interviewed the respondent and said, what'd you do here? And she said, well, I didn't know that was against the law. And I said, well, you could Google it in 2 seconds. You know, this person actually had 100 apartments. And I said, if you've been doing this to other people too, it's completely against the law. You can't do this even under state and federal laws, under the Federal Housing Act. And so she said, well, what do I have to do to make it right? And I said, well, we need to do some mediation to figure out how you can make the complainant whole. I didn't have to, it was not complicated for me. Now the mediator, we did hire a mediator. It's the only time that we've ever done that for that particular case, and that's cost $250. But in that particular circumstance, I mean, once in a while I will ask the county solicitor, what do you think about this? What do you think that this is complicated or something? But this isn't hard stuff. This is, remember, this isn't contract law, this isn't custody law. All you're doing, the only thing that the investigator has to do is look at this complaint and see if the person has bona fide, irrefutable, verified evidence of discrimination, like a signed letter from an impartial person who happened to be their supervisor, who saw the boss come in and say all these horrible anti-minority things to the person and then make their have an impact on their job. A signed letter, and I'll say that to complainants who said, I said, do you have any witnesses? Yeah, there's a few people. Well, I said, well, get the witness to sign a statement that said this really happened to you. And they're like, oh, well, I don't know about that. Could you talk to him? No, I don't do that. You have to get a signed statement from witnesses. And if you can do that, then we'll go and look and see. We'll bring it to the respondent. The respondent says, that doesn't happen, but I got to tell you, signed statements from people, the respondent usually says, okay, well, yeah, we did that. And it's been my experience that every time real bona fide pieces of, and I've been doing this for, like, 30 years, every time somebody has a bona fide piece of verified evidence, the respondent will immediately say, yes, we did this, how can we make this all right? And it doesn't go to the courts. It doesn't have to go to the courts.
If I can just ask, who came to Luzerne County or who contacted you about this ordinance? How did this come about? Why did it even come about?
Well, I think what happened and this has also happened in Northampton, and I think when county councils begin to look at this stuff, they begin to see that the news is reporting that these commissions have passed these ordinances and find that it was originally from Lehigh County, and I am the chair, and I'm also actively trying to help people to be able to pass these ordinances. I've been doing this for a very long time, and say they might talk to somebody else who said, well, how did that pass in Northampton County? It's just passed in Northampton County in March. And then the person will say, well, Liz Bradbury helped them do this, and they've used the Lehigh County law, and the Lehigh County law is very, very well-written law because it's very accessible. When you read it, you can understand it's not written in a lot of complicated legalese, and it's also very, very fair to both the complainant and the respondent.
I just want to note that I did notice that they had been passed, and how many counties have they been passed?
Well, this is the 5th county,
This is the
and
fifth.
our town, it's a big city.
And some cities have them too. I mean, I'm not sure if anyone knows this, but Wilkes-Barre City has had one for a very, very long time.
Yeah.
And Pittston as well.
Pittston, I helped to write that, Pittston.
So I noticed it, I think other members of the council noticed it, and we contacted her. So just to note that, and I
And the
believe.
$500 assessments fines that will be made if they found guilty of, if you find them guilty?
Okay, I would like to address that, because that's a fine. And instances of fines are very, very rare. I've never even heard of one. But the reason that you might have a fine is because the respondent is found guilty of committing discrimination against somebody, and they end up sort of making the complainant whole, but then they do it again. And you think, why are you doing this again? We just told you to stop, you're doing a policy that's blatantly discriminatory. And they say, oh yeah, we forgot. And then they do it again. I've never seen that happen, because respondents who have, in all of our experience, respondents who have found that they were guilty, they stop doing it. They train their people to not continue to do the discrimination. Instances of a fine are so rare. That's why this fine, it really is very low.
And that's why, you know, it just seems like there's no reason to have this ordinance. Every time I hear something, you say something, well, this has never happened, that has never happened, it hasn't cost any money,
Well,
it's not cost. So what is the purpose of this?
The purpose of it is this. When we passed this ordinance in Lehigh County, the day after it passed, every single law firm in the eastern part of the state sent out an email for every single one of their clients to say, you must stop doing these illegal hiring practices. You can no longer ask people, for example, what their salary history is. You cannot do that. That salary history ban is in the ordinance. You may no longer discriminate against people based on their gender identity. You may no longer ask people about their prior circumstances in the courts. You cannot do that anymore. To landlords, you can no longer discriminate. One of the things in Delaware County, apparently, single women with children are discriminated against in housing all the time. Their lawyers wrote out, and different kinds of housing bureaus and people who present human resources stuff. You can't discriminate against this anyway. It stopped the day after the ordinance passed. You have to think of the ordinance as a stop sign that defines discrimination and tells people they have to stop. You don't have to have a commission standing next to the stop sign to get people to stop. You know it's against the law, you stop doing it. And every time I do presentations on this, for example, somebody will say to me, I just filled out an application for a job that asked me what my prior salary history was. And I said, well, if you were in Lehigh County, that'd be illegal. They wouldn't be able to do that anymore. 20 states have salary history bans, including Alabama, but not Pennsylvania. And a salary history ban closes the pay gap, particularly with companies who are asking about salary history, by 15% in 1 year. That's why we have laws like this.
Landlords cannot ask source of income?
They absolutely can. That is wrong. There is nothing.
Sense.
Pardon me?
That makes no sense.
No, they can. They can ask source of income. The only thing it says in there is that they cannot, in the source of income section, it says you cannot deny these sources of income, like alimony or Social Security or disability payments. A landlord can't say to a person, yeah, you have enough money to pay this rent, but because you're paying with disability, I'm not going to allow you to live here. But landlords are allowed absolutely to do credit checks, to ask the person exactly what they're making, to be sure that they're making enough money to pay the rent, to have a letter of recommendation from their prior landlord. They absolutely can do that. They just have to do that for everybody, not just a single mother, not just a person who has brown skin, not just a person who seems like who has a disability. You have to ask everybody that, because you have to treat everybody fairly, and that's the point. But salary or source of income is to allow people who have income from other sources to not be discriminated against, as long as they have enough money to pay the rent.
Legal sources.
Absolutely.
Okay. Thank you.
That's
Just
your
to clarify-
time. Oh, go.
Just to clarify one more thing, I believe that the $25,000 cap that you're referring to is for the ACE Commission lawyers. We're not allowed to pay the lawyers that represent our accountability, conduct and ethics board more than $25,000 a year.
Is that's with the commission?
That's not with
That
this
doesn't
commission, that's
have
with
anything to do with this.
the ACE Commission. It's a different
Okay.
commission.
Well, then somebody gave misinformation, that's for sure.
Well, that is exactly why we are here.
Right here.
And I want to make two notes. One is procedural. You may have noticed that I said, thank you very much, Sheriff, that we give you 2 minutes for questioning and then 30 seconds for a follow-up. I just want to say that in order to make things a little easier for Liz, and this has been very, for the most part, a very civil discourse, we are letting you reclaim your time, basically. So your questions are your first 2 minutes. Her answers don't count. And then you get another 30 seconds. So Ms. Potsko, I'm going to use as an example, you did, from your questioning only, used up your 2 minutes and 30 seconds. But every time Liz spoke, it was not running. So I just want everyone to be aware of that. I also wanted to make one more note. This ordinance also expands protections beyond some protections from the federal and state. And that is absolutely legal for us to do. We can do that because the federal is the floor. Okay, we can't go below that, right? So states, for us, are the second floor. So states can't go below the federal protections, but they can give more protections if they choose to. Now we cannot go below the protections given in the state or the federal, but we can choose to go above. So for example, this ordinance protects some small businesses. And what might happen in a small business, and this, you might be a small business and you might have a client who hires you to do something, and the client, when you get there, may decide to discriminate against you, and it may with a protected class. Sorry, I can't read that far away without my glasses. Right now, in Pennsylvania, that kind of thing, I know it's on my head, I don't like to wear them. That is not protected under Pennsylvania or federal law, but it is protected under this ordinance. Another example is...
Can I explain that a little bit?
Yeah, sure.
So what we're talking about here is...
I just wanted to get to why this ordinance is important and why it's not just a duplicate of what we have in the federal or the state system.
One of the things about this ordinance that is vastly different than state law, and that will not probably ever change with regard to differences in state law, is that state law doesn't cover small businesses. So if you work for a small business that has 10 employees and 7 of them are the family of the owner of the business and 3 of them are you and 2 other people who are not related, you can be discriminated against under state law for any reason: race, religion, gender, disability, any circumstance you can be discriminated against, because the definition of employer with regard to the state is you have to employ 4 or more people. So anybody who's in a business, not counting your family, if you're in a business with less than 4 or more people, if that's the employer has less than, they can discriminate against you for any reason. We don't want any men working here anymore. They're allowed to say that based on state law. This law, the Luzerne County law, says that an employer is anybody who employs anybody. If you're talking about federal law, it has to be 15 employees. So if you're working for a company that has 11 employees, based on federal law, you can be discriminated against for any reason at all. Any reason that you would think you should never be discriminated against. But you can under federal law. And if you filed a complaint, they'd say, how many people are in the business? And you'd say, 11. They'd say, tough luck, dismissed. That's one significant thing about this ordinance that impacts every single possible person if you're ever in a smaller business.
Okay?
And I'm also reminded of the public comment that somebody made a few weeks ago when we were discussing this in council session, where she said, I haven't taken on new clients for my business in years. Would I, if somebody came and knocked on my front door and said, you have to take me under this? Well, it's not discrimination to say you haven't taken on new clients in 10 years,
Yes.
you know. And you know, in that moment, I wanted to click on my microphone and say, the scenario that you're giving us is not discrimination. If you're clearly saying that you're a business that's not hiring, you can't discriminate because you're not hiring anyone.
Right.
If you're a business that is not taking on, I don't believe she was a nail or a hairdresser, but she did it in her own home.
Nails.
Okay? And if you're not taking on new clients, you're not taking on new clients. It's not discrimination for you to say, I'm not taking on new clients at this time. It's very like cut and dry. You know, it's not discrimination to say, hey, we're not hiring at this time. We're not, it's not that we're not just hiring you, we're not hiring anybody. So.
Next, first of all, I just want to say, we want to answer all your questions, but it has been an hour, so I'm going to do something a little bit different. I'm going to call someone and I'm going to tell you who's next on deck. So that means get ready, because you're the next person to ask a question, just so you know. So Alyssa Fusaro and David Darby is on deck.
Okay, I'm going to ask real quick. I needed to correct some things, so before you make me go on my time, I would ask.
Alyssa, you get 2 minutes to ask your question.
Fine.
Jump in.
Second follow-up.
You said it hasn't cost you anything. It has cost you or it hasn't cost anything because it's offset by the fines of the people in your enforcement fund, and it's in your ordinance. Almost $200 to file with the Court of Common Pleas, not free. Only one minister on that commission that you mentioned, ministers, and Mr. Sabatino contacted Lehigh County to get this in here. What specific deterrents or penalties exist for knowingly false or frivolous complaints? Is there a reciprocal process or cost shifting for respondents who prevail beyond the private right of the action, because this will cause those accused, whether it be a citizen or a privately owned business, who will have to take off work, hire attorneys, etc., etc. Would this ordinance penalize organizations and individuals who enforce sex segregated facilities? And is gender, if so, gender expression is considered a protected class on this, given the relatively low filing barrier, a verified complaint within 180 days subpoena power, non-strict evidentiary rules at hearing, the potential for cease and desist, plus private suits with the attorney sees what safeguards prevent weaponization against small landlords, employers, service providers, or individuals over disputed perceptions or minor incidents, because this is not outlined in your ordinance. How is intimidation, coercion, difference, or segregation in treatment scoped to avoid turning ordinary disagreements, legitimate business judgments, height, weight, etc., or source of income generating into violations?
Okay, so there's a lot of questions that you're asking in there, but let me address one question, and let's see if I can remember all the things you said. I think one of the things that you were saying was, what if, so I think to simplify one of your things you were saying, I think you're saying is, what if somebody lies in the complaint? It says right in the ordinance.
Penalties.
Yes, it says right in the ordinance that if either the complainant or the respondent lies to file a complaint or to respond to the complaint, they could be subject to criminal penalties.
What section does that say? Because it doesn't.
It's in there.
I did not see that in here at all.
Well, it is. It's in Lehigh County, or I think it's in this ordinance. So it has to do with the actual filing of the complaint. And people are subject to, they have to be verified, they have to be telling the truth, and if they're not telling the truth, if they're knowingly lying, then they're subject to penalties. But let me put it up front first. You got to recognize that the investigators are looking at the complaint to see if there is verified, clear, demonstrable evidence of discrimination. It's not going to be somebody comes in and is going to use this as weaponize this or something like that, or file all these complaints. I work as the investigator. If somebody files a complaint and there's no verified evidence, it can't be weaponized against the respondent because we don't even send it to the respondent. We just say this is dismissed. There's no evidence here. We don't send it to the respondent until it is found to actually be prima facie and have, and then have probable, or getting to the point of having jurisdictional cause. So, you know, if somebody says, I'm going to show you, I'm going to file a complaint, well, there's going to be a complaint there. You don't just say, I'm going to file it, and then you're going to be in trouble. I get this complaint, and I say, well, where's the meat in this? You're not indicating what the protected class is and how you were discriminated in that way, and you don't have any evidence. So the complaint is dismissed, and it can't be weaponized unless they have really bona fide facts that are going to be able to show that the respondent had been discriminated against them. So
And the other question would this...
Alyssa, that's your time, you can come back.
Yeah, but this is the question that I asked.
I need to understand. Go ahead and tell me what...
Would this ordinance penalize organizations and individuals who enforce sex-segregated facilities?
No.
Okay, so is gender expression a protected class or not?
Gender expression, you mean how you dress and how you present yourself?
Yeah,
yes, it's a protected class.
Then it is. Then technically
this is the way this works, and this is the way it is under state law, under the Supreme Court of the state of Pennsylvania. If a person identifies themselves as female, they can use female segregated
And what about a
resources.
gender fluid person who is in the bathroom and then all of a sudden decides they're male again?
In the
Because
circumstances,
gender fluidity goes back and forth. At any moment, they can determine, and it is literally seconds, they can determine they are male again.
I haven't come across that kind of case.
Well, it's the truth. Gender fluidity.
Well, I understand what gender fluidity is, but usually people who are gender fluid are not doing that to be able to use different bathrooms. And so I think that that's kind of the deal.
But that's what you're allowing. That's what our whole...
If you are in a circumstance, for example, a school, and you say that, and this young person is saying, this is my gender identity. This is the gender identity I identify as, and it is male or it is female. Then the expectation is that that person is going to use the appropriate resource that is appropriate to the gender identity of that child or that adult, and that has been recognized by the Supreme Court of the state of Pennsylvania and also by the Pennsylvania Human Relations Commission. So even if you're saying this ordinance in Luzerne County isn't appropriate, that's the law in the state.
But isn't that left up to whoever's on the commission?
No.
To determine?
No.
I mean, and then on top of it, you
I said no.
I know, but what you're saying is, you're saying that, like I had a teenager literally tell me in front of her father that she has to use the bathroom in the teacher's lounge because somebody keeps flipping back and forth and follows her into the bathroom every time.
If somebody is harassing somebody in a bathroom, it is absolutely not protected. No, if somebody is, if there is a person who is using, let me put it this way, these laws have been in place in the United States since 1976, and there has never been an instance where a person has used the protections for people based on gender identity to let them harass somebody in a restroom. And if somebody is harassing somebody in a restroom, it is against the law. It doesn't matter whether they're female or male or gender fluid or non-binary. It is against the law to harass somebody in a restaurant. On the other hand, just by existing is not harassing somebody.
I'd also like to note that in Pennsylvania, it is a law in schools that if any child does not feel comfortable using a group bathroom or a group changing facility, they have to be allowed, they're not given it obviously, but they have to be allowed to use a facility that is gender neutral.
Private.
Private, I'm sorry.
That is private. And in those instances, that could be any child in any situation. The child could say, I am uncomfortable being around other naked people. I just don't want to be in a situation where people are looking at my body because of the condition of my body. And they can say in their school, I want a private changing area, I want a private place to go to the bathroom, and in the state of Pennsylvania, based on court rulings, they have that right. That's not something that's in your law.
About federal law.
I don't think federal law has that.
Federal law,
Can we proceed
Mr.
to the next
Mr.
question,
Randy,
please?
please. David Darby, thank you, and John Frey, you're on deck.
Okay, Dave Darby, City Wilkes-barre. I was curious how many complaints your county is getting a year. How many are you investigating?
Yes, so I have mentioned this already. Since we've been running we get a little bit more complaints as we go on because more people know about us. We have had 16 complaints in the 2 years that we've been running, at an average of 8 complaints a year. Of those, we have found significant instances of discrimination, but very few. It's turned out to be 2 complaints. One was against a person based on their disability, and a very serious complaint, and the other one had to do with the person's gender identity.
Well, it's just a short follow-up is, if you feel the ordinance is necessary and the volume doesn't seem too high, is there a reason you couldn't have an employee of the county actually do this investigation, such as the
Well,
district
you'd have to
attorney's
pay
office?
them, and you'd have to pay me.
Well, I would feel better if an actual employee of the county did the investigation and the
Well,
findings.
Human Relations Commissions are based on the concept that the commissioners will be a broad swath of the community, representing a lot of different kinds of folks, old, younger, different ages and different races and different circumstances, different instances of gender and different instances of religion, and that's why they're set up that way. They're specifically set up that way. But don't think that just because we've only had 16 complaints, because first of all, that, people say, oh, there's going to be chaos, there's going to be hundreds and hundreds of complaints. And I've heard people post, or I've seen people post, there's going to be chaos. Well, obviously it's not chaos. It's 8 complaints. But on the flip side of that, our website, which has our human relations ordinance, has about 300 hits a month. And I think that it's likely that people are reading the ordinance to see what their rights are. Because if there is a law where they're protected from discrimination, which they have been experiencing, they can say to their boss or their landlord or their parent, I guess, no, that wouldn't be their boss or their healthcare provider or in their school, and they could say, there's a Human Relations Commission in this county, and it doesn't just protect on race, religion, and ethnicity, it includes domestic violence status. And you can't throw me out of this apartment because I'm a victim of domestic violence because you've heard that that's the case. You can't do that. And they're advocating for themselves based on the law.
Well, thank you. I just thought I'd stress, I think it's good to have an employee implement ordinances, somebody like the district attorney's office. Thank you.
I'd just like to note that on our APCs, you can't be employed by the county. That's
correct.
part of our charter.
Yes, if I could speak on that. For the authorities, boards, and commissions, you cannot be an employee of Luzerne County and serve on that authority, board, or commission. Yes, for a year, right? So there has to be a spacing gap, but you cannot be employed by the county and serving on an authority, board, or commission at the same time. That is not allowed.
Now, in the HRC ordinance that was introduced, establishing the commission, which in Luzerne County, to answer something that Walter Griffith had said earlier, we can only do one thing in one ordinance and one thing in another ordinance. They have to be 2 separate ordinances. We can establish the right to create the commission, but to create the commission, it has to be a separate ordinance. But in that ordinance, the administration falls under the purview of the county manager and the Office of Law. So they theoretically, if there was a burden of more than 8 cases, and this is where future costs might come in, could hire somebody to do the investigating or assign somebody from the administration to do the investigating. We've left that open for the county manager to make that decision.
Next. I'm so sorry. John Frey, and on deck is Joe Grantee.
Ready?
Yeah.
Will I violate this ordinance if I require a prospective tenant to provide proof of employment and sufficient income to cover rental costs before agreeing to the rent to that person? Yes, no?
Absolutely not. You would not be violating this
Yes,
ordinance.
no?
I said no.
Right. Will I violate the ordinance if I require proof of legal citizenship before renting to a person? Yes, no?
Yes.
I will be violating. the
Yes,
ordinance.
because this person could have a green card.
Well, that's legal.
Pardon me?
That's legal.
Yes.
Will I violate
If they
this ordinance
illegal-
if I request proof?
You can, okay, so let me talk about that a little bit. If you are, no, if you are a landlord, you can, and you have a person that comes to rent the apartment, you can require of every person proof that they are legal citizens of the United States and authorized to work. They don't have to be citizens.
So
They
that's not a
have-
violation of the ordinance?
No, and let me finish.
Mr. Frey.
The person, you can ask the person if they are authorized to work in the United States. And the reason you can do that is, that's a really legitimate question to find out whether or not they're going to be able to pay their rent. And you're absolutely allowed to do that. You can check their credits, you can look at all of their circumstances, you can get a letter of reference from their last landlord, you can say, I need to know exactly how much money you're making, and I need a note from your employer that says that, and I need to know that you're going to be able to continue to do that. Now, you might have somebody that is a tourist from another country, and they say, I am allowed to be in this country for 6 months, and I want to rent this apartment. And you say, well, how are you going to pay the rent? They say, here's $20,000. That's all I'm going to pay. They don't have to be a citizen to rent the apartment. It's not, and you are not responsible about, you're responsible to gather the rent, but they don't have to have a job. They just have to have the money to pay the rent, right?
I'm not asking about a job, I'm
Okay.
asking about citizenship.
Yes, so you absolutely can ask the person if they are authorized to work in the United States.
So I'm not in violation of the ordinance.
You would not be in violation if you asked the person if they were authorized to work in the United States and had a job and could prove that they were going to pay the rent.
Oh, okay. So
Okay.
yes, no, no.
Yeah, correct.
Will I violate the ordinance if I refuse to rent to a family consisting of more people than the unit can accommodate?
Absolutely not, and that's in the exemption section. It's letter B, and it says nothing in this section will require a landlord to rent an apartment with the number that would be beyond a circumstance of safety.
There's something there about familial status.
Familial status means children of the parents. It doesn't, you absolutely are allowed to say, this is too many people in this apartment to be legally safe. I have a rule, and you don't make that rule, that has to do with codes. And you could say, well, there's 11 people in this bedroom, that's not acceptable.
Good.
You absolutely have the right to
I'm
do
not going to
that.
violate it.
Good.
Will I violate the ordinance if I refuse to rent to someone that owns an animal or animals?
No.
Define therapy animal.
If you are a landlord, you can have a no pets policy, and you are absolutely allowed to do that.
Okay.
You can say nobody can have a pet. However, in the United States, based on federal, state, and Luzerne County law, if the person has an emotional support animal, they are allowed to have it in their living space, but they must produce for you, and this is under federal, state, and Luzerne County law, they must produce a bona fide signed letter from a real licensed mental health professional who says this person has to have this animal, and it has to be an appropriate animal for the size of the apartment. They can't have a giraffe. So, this person is allowed to have this animal because it is part of the treatment of their mental health illness. That means that you can't charge them more for the animal, but you absolutely can charge them if the animal makes a mess or screws up. You can also say if the dog is barking, get it out of here, it's bothering everybody.
That was the other part.
Okay.
Can I be compensated for damage?
Yeah, absolutely, absolutely.
All right. Now,
Let me say one more thing about that. Because when you talk about emotional support animals are only allowed under this law in the person's living area, their house or their rental property, in that circumstance. Service animals, like the kinds of dogs that people have when they can't see, and they have a seeing eye dog, or they use a wheelchair and the dog helps them stand up, and they're bona fide service animals, they are allowed to go anywhere. They can go into restaurants, they can go, and they have to be trained, they have to have a specific thing. It's not the same as emotional support animal. Fluffy the rabbit can just be something somebody pets, but you don't get to bring Fluffy into the grocery store. But Rex, the seeing eye dog, who is a bona fide service animal, you do get to bring them into the grocery store.
Now, you said that if the commission makes a mistake, it has to be investigated, and will be investigated by someone on the commission.
I didn't really say that, but I'm not sure what you're referencing.
Well, if the commission makes a mistake, and you said they might.
If the commission makes a mistake, they can't be sued. That's what I'm saying.
But a respondent can appeal to the court of common pleas. That's what she said.
Well, who does the investigation? You mentioned investigating the mistake. Who does the investigation?
No, I don't think I said anything about that. But I can say that if the respondent believes that the commission has...
Didn't you say you do the investigating?
I investigate for Lehigh County, yeah.
Okay, you're part of the commission?
Yes, I'm the chair of the commission.
Someone on the commission does the investigating.
I do the investigation of the initial complaints, and if I make a mistake, I can't be sued. Let me put it that way.
No, I'm not talking about suing.
Okay.
I'm just...
No, I'm not sure what the question is.
Well, the question is, if the commission itself made a mistake, what is the remedy to that?
The remedy for that is to have the determination overturned by the courts.
By the courts.
However,
Who pays for that?
if you're talking about, remember that there's a lot of different levels of review.
I mean, there's two sides, right?
No.
There's the county side and my side.
No, not at all.
No.
There's the complainant and the respondent, and the county's in between. And they're looking at both sides. And remember, the very first thing the county
So that
does...
won't cost the county anything if there is a problem of that type.
I don't...
If there's an investigation and it has to go to court, and there's a complainant and...
The thing is, the circumstances of that are very unlikely, but let me put it this way, let me describe it again.
The county won't have to pay anything.
No.
Good.
I don't.
Simplify that.
No.
The other thing I'd like to know is, how do you substantiate perceived discrimination?
Okay, so it's not perceived discrimination, it's actual or perceived circumstance of a protected class. In other words, you don't have to prove that you are Puerto Rican if somebody discriminates against you because they perceive you to be Puerto Rican. That means, and one of the circumstances that happens with these laws is that if somebody in the past is that, and you don't have actual or perceived in there, somebody ruthlessly discriminates against somebody because they perceive this person to be Japanese. And then the person says, you can't call this a hate crime, or you can't call this a discrimination, because that person turned out not to be Japanese. And so it lets the discriminator off the hook. Well, actual or perceived means, and it's a legal term, that regardless of whether or not you are that minority, if you're being discriminated against based on the perception that you're that minority, you are protected. So that the person who was just doing discriminating came back and says, oh, it turned out that person was white, so I wasn't really discriminating against them. No, that's not the way it works. Okay?
Okay. And will this ordinance... Oh, I'm sorry.
Please.
I exceeded my time.
Just for the record, I am keeping track of time, but sorry, sir, your name is Mr. Frey.
John Fry, Plymouth.
So when Mr. Fry is asking the questions, that's when the time is clicking?
That's what I tried to explain
When the
before.
answers are happening, I stop at the clock, so...
I'm talking so long, it seems like longer.
Yes.
Yes.
Well, yes and no, but you're getting a lot of great answers out of it. So it, just basically out of respect to Mr. Fry, I'm pausing the time during the answer session so that he can then ask more questions, and I think that that helps because we're covering more ground that way, so.
Should I say
And you should know. You have one more question, ask me.
You have one more question, Mr. Fry. You had about.
You can come back later, too,
You had
because I
about
love
5
this
seconds
question.
left. You had about 5 seconds left before.
And this is it, and now you have to sit down and come back around.
Well, the natives are getting restless.
Well, we have a lot of people with a lot of questions. We have a lot of
This
people with a
ordinance
lot of
allows
questions.
my granddaughter, my grandchildren, to use restrooms, locker rooms, shower rooms, etc., with individuals of the opposite sex.
Based on the interpretation of the state's human relations ordinance and it's the current state law, people who identify as male or people who identify as female are appropriate to use the gender identity restrooms that are appropriate. Your granddaughters, believe me, if you talk to them, they probably won't be uncomfortable with transgender women. I think it's unlikely.
I would disagree, but that's.
Okay, well, talk to them.
Next, thank you. And after Mr. Grantee, Johnny Sudal is on deck.
Joe Grantee, Plains Township. I will be uncomfortable watching little girls be followed in the bathroom by males, men, whatever you want to call them. What is a woman? What is a woman? Is this thing on?
Yeah.
What is a woman?
Is that a question?
Yes.
It's a person who, based on state and Luzerne County law, it's a person who identifies themselves as a woman. It doesn't matter what their doctor says, it doesn't matter what their parent says. You get to decide what your gender is. You get to decide, not the government, not somebody else, but you. You get to decide what your gender is.
I can be a woman in the morning and a man in the afternoon, and that's something that you approve of.
Is that something you do?
That's real funny. That's not a joke.
Okay, well, in the state of Pennsylvania, a person who perceives themselves
The state
to be...
is wrong.
Well, okay. But let me put it this way. You can contest this local law, but the state law is still in place.
We have federal laws that protect women in...
Federal laws do not supersede the state.
They don't supersede the state, but...
Not in this case, like I explained before, federal is the floor, right? State can go higher.
I understand.
So the state gives higher protections.
One of them
So
is
federal
right,
laws don't
one of them is
supersede
right,
that.
and one of them is wrong.
That's nice of your opinion. You have another question?
Lehigh County. You said you had 8 cases in 2 years?
No, I said
16
8 cases a year.
8 cases a year, 2 of them were adjudicated.
No, I didn't say that. But go ahead, what's the question?
One of them was a disability case, and the other one was a gender case.
It had to do with a person who had explained what their name was to their company and explained, and by that, and then their boss came to another company where they had gotten a job and outed them and made a lot of disparaging remarks about them and said all sorts of negative things about their circumstances and gave inappropriate personal information to the supervisor.
Does it have anything to do with pronouns?
No. And in this particular situation, they told this person all of this information, and the supervisor was shocked that this person would come and make all these disparaging remarks about this person's personal protected class circumstance. So that supervisor gave a letter to the complainant. And what happened actually was that the complainant had given the information to the company and said, this is my legal name, and the company had put their chosen name, not their legal name, on their W-2 form, and when the complainant said, that's not my name, they said, yeah, tough luck, use it anyway, when you file your taxes. So in those circumstances, It was a bad situation. They had a signed letter from their supervisor that demonstrated this discrimination, and they proved their case. And when we sent this to the respondent, which was a very, very large company, the lawyer for that company, is a national company, came back and said, this is against our policy. We retrained this person. We're terribly sorry this happened. It was very uncomfortable for the complainant. We understand that this was wrong, and we will never let this happen again.
How many people live in Lehigh County?
357,000.
So it's bigger than.
Little bit.
It's bigger than
Little bit.
Luzerne County.
No.
69.
Yeah.
Oh,
Yeah,
369?
we're at 369,000 here in Luzerne County.
And we've got 2 cases out of 357,000 people.
No, I don't think you should look at it that way. I think once you have it, this is like a...
Okay.
Well, okay, but you should actually ask yourself, and
She's been...
Mr. Brantee!
Been going on and on and on.
Mr. Brantee, don't make me do this again with Walter. Come on.
I'm asking my questions where I want to ask them.
Just be respectful.
I am
Everyone else
respectful.
has been managed
I'm
to be
being
respectful.
respectful. I'm asking a question.
Stop talking over me. Allow her to answer your question. I'm running the meeting, sorry. Allow her to answer your question.
I did.
what I want to say is, I think we all need to look at this law as a stop sign. And once again, when you tell people what is illegal discrimination, they stop. So the law itself is the thing that protects people, not the commission, not the filed cases. So that when somebody says, somebody comes back to the circumstance of a young woman who has a child, and she comes and says to the potential landlord who says, yeah, we're not taking any girls with kids anymore. She comes back and says, you can't deny me this. I have the money to pay the rent. You're discriminating against
You're
me.
looking for a problem where there isn't one. 2 cases out of 357,000 people. Sorry, that doesn't sound like it needs to be
Okay, but
happening.
here's the deal. Since this isn't going to cost the county very much, why not protect veterans? Why not protect disabled people? Why not protect widows and single mothers and senior citizens, all religions, including being not religious, pregnant women, people who use wheelchairs, people with emotional support animals, there's one in this room, people who are victims of domestic or sexual violence, people over 40, people who care for the disabled, divorced people, people with cancer, heart disease.
You know what you're missing? You're missing businesses.
Businesses are absolutely protected by this.
Let her finish.
Mr. Garrity, you've proven that you can't do a question and answer. You are having a debate. This is not a debate. The podium is no longer yours.
No, I'm reading from the list of people who are protected by this ordinance.
Mr. Rantine, sit down, you're done.
Okay.
The podium is no
Thank
longer
you,
yours.
you're done.
My time is not up.
You're
You
done,
don't get to
because
come
you
here
cannot
and do
follow
a debate.
rules.
This is question and answer. You
I
question,
didn't
she
ask my
answers.
questions. She's
Because you're debating
She's
our experts.
answering-
And now you're debating
not
me.
debate.
Get away from the podium, sir.
Why does everyone else behave, except for just a couple people?
Who is next for the next public question?
Thank you, sorry.
Johnny
It's
Sudol.
Johnny Sudol, and Michael Polgar is on deck.
Weaponization.
Anybody else?
Johnny Sudol?
Johnny had to go.
Yes, I did see him, I don't know. if
I
he's
did,
able to
maybe he left. Michael Polgar? I'll pull it and say that maybe he can run to the bathroom. And after Mr. Polgar, is that how you say it? Yay, nay? Is Paul Lott.
So my name is Michael Polgar. I'm in Kingston, one across the river. Is that the borough or the township? I don't know.
This is Borough.
Borough, thank you. You've answered my first question. Thank you very much. Thank you to the commission, or to the council. Thank you to the expert. Liz Bradbury, your presence and your articulation in a hostile environment is more than appreciated. It is honorable and appreciated by many who are not here. So I hope I speak for the county when I say thank you for visiting us and showing your expertise. My understanding is that there are violations of law, and there are complaints, and there is discrimination, and there is prejudice. The violations of law, such as hate crimes, are indexed by the FBI and include violations of law that are motivated by race, ethnicity, ancestry, religion, sexual orientation, disability, gender identity, and bias-motivated crimes numbered over 70,000 in the United States, including the burning of our governor's house. That's hate crime. That's a violation of law. Discrimination is sometimes a violation of law and sometimes not. So it's a gray area. My understanding is that prejudice, attitudes of aversion or hostility towards a member of a marginalized group, is not always and rarely a crime. So that this ordinance deals with behavior, not prejudice or attitudes. Is that correct?
Yes.
That is correct.
Yes, you're right.
It has been asserted that this ordinance does not address a real problem. So I would like any of the council or Ms. Bradbury to explain why discrimination is a problem in the United States, in Pennsylvania, and in Luzerne County in particular.
I think that when you come to these rooms and you hear people talking, you can understand why prejudice has to be, and why discrimination has to be in laws or prohibited by law. I mean, I've read a lot of the comments that people have said, and they were hateful, ruthless, horrible things that people have said in comments with regard to the news articles about the passage of this law. And when you see these people who just say these, I mean, one person who just said some of the most racist things I've ever seen, comparing human beings to dogs based on the color of their hair and things. When you see something like that, and these are people who are local because they're proudly saying that they're local, do you think that person wouldn't discriminate against somebody? I mean, would they not say, yeah, I'm not going to hire you? Would they, if they worked in an office and they said this person has this instance of deep hatred against people, or somebody who would think that because there's one person that they've come in contact with who is gender fluid, we shouldn't protect all these other people? It's just unbelievable to me and surprising to me.
Do you think, in your experience with
Is that your time?
Yeah, that
That's
was
your
fine.
time.
Sorry,
You can come back around if you.
Okay, okay. Thank you very much.
Thank you. And Paul Lott is next, and Mary Lott is on deck. And I would just like to thank the members who have been here, the members of this audience who have been here, who have been so respectful.
Got a couple questions as to the text of the ordinance.
Sure.
I totally understand the piece about illegal immigrants. You can find in section, I think, 201, that it applies to federal law, whatever. But in section 302, where you, in paragraph C, the language is ambiguous, where it says an employee may not elicit any information to make or keep a record of or use any form of application or application blanketing question concerning the protected class of the applicant for employment. So if that includes citizenship status, that means this is stating that you can't inquire it. Now, obviously federal law overrides that, but the way this is worded, that would give someone the impression that they couldn't ask those questions. That's my first question.
Keeping data on a person is, and it is true that the way that's written, I guess you could see it that way, but it's clear that people are allowed to, even protected class status. I think it's clear that people are allowed to discriminate. I mean, there's so much information from the federal government that you have to collect information with regard to a person's right to work in the United States. But because, you know, when you get a job, you have to fill out like a 19-page document, and everybody has to do it, even if you were born across the street. But in terms of collecting that information, you can, many people will collect that information and in instances of hiring, and they will require a person to fill out all these pieces of information with regard to their protected class status. What race are you, what ethnicity, what religion, and people are really reticent about filling those things out, and they say, I'm concerned that the employer is going to use this to discriminate against me. So when we wrote this law, we made the decision to, because people say, well, I just do that to prove that our company is really willing to do outreach to a lot of people. I said, well, figure out a different way of doing that rather than asking everybody personal questions about their age and their race and circumstances like that.
With respect, you said that this could be interpreted the way that I said it. That means that it is not clear by definition.
I think that somebody could see that they would not be able to ask that on a document that was collecting data about people. That's what that is about. And it says that, collecting data on the person. But asking somebody if what their it's not citizenship status, it's whether they are legally authorized to work is separate from that.
May I speak? It says may not elicit any information or make or keep record of or use any form of application or application blank. I understand what you're saying. I'm saying that what you're saying and the text of this section, this is more ambiguous than what you're saying.
It's talking about citizenship, though.
No, it's talking about protected class.
Oh, protected class.
And
Yes,
in
I understand.
protected class, right, it has citizenship
Right.
status, which has a federal requirement on it.
No, you're misunderstanding. There is no federal requirement with regard to citizenship in the United States. You don't, the citizenship is, when people are arrested, they're not arrested because they're not citizens. They're arrested because they're illegally in the United States.
I'm so sorry, but you're not addressing what
Okay,
I'm saying.
I'm sorry.
You're responding to something that I'm not talking
Okay,
about.
I'm sorry.
I'm talking about the ambiguity in the language of the ordinance.
Can I just ask you to
That
make
if I
sure?
take it that I'm looking abstractly, that statement can cause confusion, which means that, people come and said, the way this is written is the reason why so many people think that illegal status is protected by the ordinance, because the language here, although you can vet it and go to the Immigration Act of 1986, which specifically has a list of definitions of what's legal status, all of that's there, but the average person, I did, because from section 201, it references a federal law. The federal law defines what citizenship status is applicable.
Right.
Most people are not going to do that.
Well,
They're going to look at the language.
it's
of
legal
this-
language, though, and I think that's why we put it in there. It's legal language. Citizenship is not a reason to not hire somebody.
I relocated here from Ashburn, Virginia.
Okay.
I've been writing legislation for years for the Virginia legislature. I was the education advisor to Glenn Youngkin. So I understand language, I understand legalese, and I've written state laws before. And I'm saying that this is ambiguous.
Okay.
Although when you vet it, you can, so there's that piece. That's that question. I do think that
I'm sorry,
should be
the
reviewed.
time is done.
Yeah, we crossed the thing about 10 seconds ago. I let you finish your thought.
Yeah, and I'm sorry, I want to ask a question quickly.
Sure.
I just want to make sure I know what section you're talking about. I thought you said 3.0.
Now, 201 gives the definition.
I understand, no. The first one that you said was 302.1C, is that what you said?
Yeah.
Right? Okay.
Hold on, it's my page.
That was the
I'm
first one.
talking about 302C.
302C. Okay, thank you. Your time is done. And
thank you.
Ms. Mary Lott, you are up.
I just have I'm Mary Lott, I'm from Wilkes-barre, South Wilkes-barre, and I just have
And one moment. There's an anonymous question who is on deck, so I don't know who that is.
No, they're just going to read it out loud.
There's no.
I think that's what they said. I want to read it out loud.
I'll read it.
Good luck.
Jimmy. I think it's, you can figure it out. I'm sorry, go ahead.
Okay, I'm Mary Lott, I'm from South Wilkes-barre. I've lived here all my life. And I just have a little simple question. Maybe I can answer two. The one question is what gives you guys the right to decide on a commission And what is so wrong about letting the people vote whether or not they want this commission to exist?
Let me address, I'd like to address that since you asked it. I think that in the history of the United States, allowing the majority to decide whether the minority should have equal rights ultimately is a terrible idea. And if you think about other minorities, would you ask people in the United States, people who have been discriminated against in the South, for example, in Mississippi? I understand. Do you think your neighbors should decide whether or not you have rights? Or should it just be that this is America where everybody has rights?
America is a majority rule. We are a Democrat Republican. We are not democracy where everybody gets equal vote. So the majority should get the say.
Really?
Yes, the majority should get the say. The
I'm glad
so far has run quite well with the majority getting the vote.
I think it took about...
Wait a minute.
You have a second question, ma'am?
Yes, I have a second question. The second question was, what gives you guys, the commission, you guys the right to put the commission in when you can put your own prejudice and discriminatory people on this commission? Because you guys are not non-biased. You already expressed your views, and you guys have pretty much supported her view on everything, right? So what makes it this commission supposedly voluntary commission with people that you guys are going to stack up? So we're not even going to vote on the commission. We're not going to even vote on the voluntary commission, the people that are going to vote. So that means that whatever your prejudices are, you're going to subject us to it.
Can I ask you a question? What's your fear? What are you afraid of with regard to the Human Relations Commission?
Here's what the thing is. My thing is this. We are in the United States of America, right?
Yeah.
And we're supposed to have the right to vote, the majority, and that's what we're supposed to stand for. Now, I live in Wyoming Valley almost all my life, and we have people we have interracial marriages, we have gay people, we have all these people living together with no problems. So then you guys come here and say, well, there's a problem. And then you're going to creating a problem.
I don't think
and listen, people who are from all these counties that you mentioned, they have problems that are overflowing. This so-called commission and stuff.
Ms. do you have a question?
I've already asked the question.
Okay, let me answer it then. I think that we in the United States have a representative form of government, and we elect people, and those people are elected by the people who then turn around. Yes, the majority of the people elect people, and the elected people, and they elect those people to do what those people believe, based on the people who have elected them, is right for the community.
But there was also, a couple of years ago, there was a little survey going around, and it asked questions about these specific things that you're talking about, and a lot of people gave a negative response to what your commission wanted, what people wanted, and so it looks like you guys are saying, well, people do not want this, but we're going to give it to them, and they're going to like it.
Well,
and
I think what happens is that... Okay, thank you. Anybody else? What else are we going to do now? Jimmy, did you want to ask a question? Go ahead.
You have it.
Does this apply to families discriminated against by their neighbors?
So the tricky circumstance of people who are discriminated against in a community is that has to do with the quiet enjoyment of your home. And if there is a circumstance where the person who is the complainant, and this is a much more complicated demonstration, it's sort of a public accommodation or housing complaint, if the people who are stating that they are being discriminated against, they would have to demonstrate by real evidence that the neighbors were doing things to them based on their protected class that were making their living situation untenable. And that's possible. It's possible that they could say, well, you know, they hung up this, here's a good particular circumstance. I had, when I was on the Allentown Human Relations Commission, there was a person who was living in a house that that was for people who have mental and physical disability. And those people in that building it was a large building, and they all lived there. And some of them were very afraid, because it was a great building, and they got reduced rent, and they were afraid that they'd get thrown out, even though there wasn't any sense that that was really going to happen. But they were worried about it. But there was one woman who said to me, she contacted the Human Relations Commission, and she said, we are being discriminated against based on the people who are in this building who happen to be employees, but they're insulting us based on our mental health circumstances. I said, how? How is that happening? And she said, well, besides calling us names, they're hanging up signs with jokes about people who have mental illnesses and rude memes against people who have mental illnesses, and they're putting them all over the walls and everything. And everybody else has to walk down the hall. It's really uncomfortable, and it's making a lot of people very sad and worried. And I said, well, have you spoken to management about it? And she said, yes, but they won't do anything. I said, do you have any proof? She said, I have the stack of signs. So I went and looked at the signs, and then I went to management, and I said, is this really happening? Is this really happening to people? And she said, well, yes, it's happening, and I know it's very uncomfortable for all the people who live here, but I can't get these guys to stop. I said, aren't you their boss? And she said, well, yeah. And I said, well, tell them to stop. Tell them to stop and make it stop. And she agreed that she would do that. She said, are you going to fine me? And I said, no, I want you to make this stop. If you don't, we might fine you. Allentown had the ability to fine up to $50,000. Never knew that happened. That never happened. But I said to this woman, make this stop. Because I asked the complainant, what do you want? And she said, all I want him to do is stop. And so that was a circumstance where these families in this building were bothered by other people in the building. And yes, you could prove that with evidence. But it would have to be proved by evidence. And I think it's the same as every other complaint. Another?
Francesca Gallant and Tyler Myers is on deck.
Tyler Myers left.
Is he gone? Thank you. After Tyler Myers, Mr. Grantee is on deck.
Thank you for taking my questions. With all due respect, I'm not fluent in Lehigh County. May I, at all?
It's okay.
May I please have your credentials as being the author of this law, the trainer, manager, and so forth? Present to us your background that gives you that knowledge.
Well, I was trained as a teacher.
And I mean it respectfully.
Okay, I was trained as a teacher, and I was trained as a college teacher. I was also took part. I mean, this is a long time ago. I'm almost 70, but I was trained as and worked as a person who did a series of committees on civil rights in the college where I worked, which was the State University of New York. When I started to work on civil rights work, and I've been doing that since 1979, I began to help to write policies. I wrote a policy for the State University of New York. And that was when I was in my 20s, which was 50 years ago. And I began to work in the 1990s to create civil rights work. I worked with a lot of professionals who were writing non-discrimination law in the state, in Allentown, because I worked on the Allentown Human Relations Commission, and I was on the commission for a long time. I was on the commission for 15 years, from 1998 to 2012. 2014, and I acted as the primary investigator, and I did that by working and understanding the law, watching what happened on the commission for many, many years, recognizing that the commission needed better training. I am a professional trainer. I worked at the Bradbury LGBT Community Center, where I trained 300 different organizations from 2016 to when I left there about 4 years ago. It was 17,000 people that I trained, everybody from police departments to people who are child care workers. And I've worked to do this in many, many circumstances.
And again, your field of expertise in the professional training is relative to this?
To civil rights work and policy writing.
Okay. Thank you. Next question is people that are, and I'm looking for the proper word.
Okay.
How do people arrive at this commission? Are they elected, appointed, selected? What do their qualifications or criteria?
When people apply for a commission, usually the county, and this is true for all commissions, I'm sure, the county will give them an application form. I know when we had called for applications for the Lehigh County Human Relations Commission, we had about 27 people apply. They provide a resume. They have interviews by the county people. That was county manager actually interviewed them. We asked them to read through the ordinance to be sure that they understood it, because that's really important. They also have to be able to use a computer and do Zoom. That was important to do as well, because if that wasn't the case, they weren't going to be able to do that. After they got onto the commission, many of them took part in trainings. We did, I had at least one training with the state, but state really doesn't train. So I worked with a number of different people who were on the council. Some of them were elected officials. I mean, they're very broad in terms of the different people. One of them was a college human resources director who was in his early 30s. We have people who are retired who have been working with civil rights for years and years and years, and worked with different organizations that would help minorities. There were people who were working in certain churches that were providing outreach to people who have problems with poverty and drug and alcohol abuse, all that kind of stuff. And I think that makes people sensitive. But again, the actual process of sort of looking at these complaints is pretty logical. You just look at the complaint, you see if the person can describe and provide evidence of discrimination, and then you go.
I'm not looking at the complaint itself.
Yes.
I'm looking at the board, their
It's a commission.
qualifications. In other words, this is sounding like, to me, an outsider, not really paying attention to anything other than coming here to see what this is all about.
Okay.
From my perspective, I am receiving the perception that this could potentially be a group of self-appointed or predisposed personal opinions, lacking in educational background, whether it be psychology, law.
I'm sorry, that's your time.
Well, can I say that one of the things that happened with our commission is a number of the different different board of commissioners wanted to be sure that people were appointed from different parts of the county. And we have a big city in Lehigh County, we have Allentown. So one of the things they wanted to be sure is that people came from all over, not just the big city. And and they also wanted to be sure that there were people who were business owners who would really understand some of the circumstances. So they made sure that there were people who really understood and were involved in rental income with real estate, and there's actually a particular person who's very well known in the community, who was very well known to understand the circumstances and requirements of real estate and real estate sale and stuff. And they tried to do that. They tried to really balance the commission.
Just one more follow-up for you, ma'am. In our charter, you do have to be a resident of Luzerne County and a United States citizen to be on an authority board or commission. But we hope to cast a wide net and actually recruit people from the real estate world, people from the business world, people from chambers of commerce that throughout the county. We don't just want people who think or act in one way or form. We want to try and cast a wide net to get a wide variety of people on this and represent all facets of the county.
Yes. Mr. Grantee, we're going to try, Mr. Grantee, please, give me 1 second. We're going to try this again. I'm going to remind you, this is not a, please let me.
Be fair to me?
Yes, and that's what I'm trying to do. Please remind yourself, and we're going to remind ourselves, this is not a debate. we're not going to talk over each other. Okay? So we're going to try this again.
Keith, Plains Township.
Thank you.
You said you spent time training law enforcement.
I did.
How much time did you spend on constitutional issues?
They're really, in terms of constitutional, with relationship to this law?
Well, no, to any law.
Well,
To people's rights.
I know.
Does this open the door to non-citizens becoming law enforcement officers in our county?
I don't know. Is there a rule that I guess, well, let me put it this way. If your county wanted to hire somebody and the person wasn't a citizen, but they had a green card in the police, sure, but it wouldn't be from this ordinance. It would be from federal law.
So it's okay to have non-citizens carry out constitutional laws in this?
I think there are many, many people in this country who are not citizens who have very, very responsible jobs, including police.
Responsible jobs. I'm talking about law enforcement.
Yeah, I'm talking about, well, I think that's responsible.
You said jobs.
Oh, I do think police are responsible.
Mr. Grantita, I just want to add something. So legal permanent residents are not citizenship, or not citizens, but they could be a law enforcement, legal permanent residents, people who have a green card. They could be law enforcement officers.
Do we have any here?
I don't know that, and it doesn't matter, and frankly, that you can certainly do that, go for it. But if you have a work visa here, you can be a law enforcement officer.
Right.
But if you are illegally in this country, you cannot legally be hired. So you cannot, wait, please, so we could not legally hire you as a law enforcement officer.
Right.
Please remember that distinction.
If you're not legally in this country, does this shield an illegal alien from divulging their citizenship in order to rent an apartment?
Does it shield? No, I mean, the person has a right to ask somebody, a landlord has the right to ask somebody whether or not they are authorized to work in the United States.
I didn't say anything about work in the United States.
Citizenship is a protected class.
If they can be shielded to get an apartment. I didn't say anything about
I don't know what you mean by shielded.
Well, if I'm an illegal alien and I come to you for an apartment,
yes,
right, and you say, "Are you a citizen of the United States?"
Yes.
I don't have to do that. I'm a protected class.
If you can say to them, this is what the landlord can say, are you legally authorized to work in the United States? And then you say to them, prove it. And they have to prove it. And if they don't prove it, you say, I'm not going to rent to you.
The other thing I wanted to ask you, source of income.
Yeah.
Does it shield anyone from divulging their source of income to get an apartment?
Shield them from divulging?
Do you mean, does this ordinance
If I'm a drug dealer and I have cash out the wazoo, do you have to rent to me?
No.
No?
Not if you can't prove any other source of income. And look, this is what a landlord can do. If the person has cash out the wazoo and the landlord says, I want to see verification of your legal job, the landlord has absolute right to do that.
I thought you didn't have to divulge your source of income.
No, that's not what it says. What it says is you can't deny a legal source of income. So in other words, suppose a person is living in an apartment and they have a job, but they don't make quite enough money, so they also have child support. Mm-hmm. And the landlord says, I'm not taking somebody who's giving me child support. They're not allowed to do that, as long as they have enough money to live there. If you have a circumstance, so that you can ask the person exactly what their source of income is. Tell me if you're going to pay me, you have to show me exactly how you're going to pay this. Show me how much money you're making. And if you're not making enough, and you say, I'm making an additional amount of money because there's a special Catholic Church program that's giving me $100 a month for the next year. And here it is, and I believe, and it lists the different things that you can't deny, but if you're getting that money, then the person can't say, yeah, I don't like Catholics, I don't want to take that money. You have to allow a person to use legal sources of income, Social Security, for example. Section 8. Well, not Section 8. No, Section 8 is absolutely not required by this law. So, I mean, people can take Section 8, but under this law, if you don't want to take Section 8, you don't have to. It absolutely exempts Section 8. Because that's a federal, one of the reasons for that is that that's a federal housing program that requires really stringent inspections in the space, and so therefore you don't have to submit to that. You don't have to choose to do that.
One of the other things,
that's in the exemption section.
One of the other things I'm concerned about is the weaponization of Luzerne County.
Weaponization of Luzerne County.
Yes, if nobody can be held accountable, if there is no, if there's immunity for officials.
Finish your thought, please, and that's your time.
I'm trying to. If there's immunity for officials,
for government,
doesn't that create a situation where a place like Luzerne County that doesn't have a stellar reputation can be weaponized against anybody who speaks up? And
no, it doesn't. It doesn't. I think you're really not understanding this. I think the whole circumstance of weaponization of the county based on this law doesn't make any sense. But what I can say is this: in the United States, government is exempt. It has statutory immunity. Every single government situation has statutory immunity. That's not unique to Luzerne County.
So
it's the way it is.
weaponization never happens.
I don't understand what weaponization means. You mean guns?
I don't know what you mean.
What do you mean by weaponization? I don't understand.
Just targeting citizens who don't think the same way you do.
No.
Maybe
No.
If somebody comes to me and wants to dress like a clown, and I want to call them a clown.
I don't think there's anything wrong with you calling somebody who's dressed like a clown a clown. I think that's completely supported.
Thank you for that. That was much better. Thank you for your
Thank you very much.
respectful. We do have repeats and we will get to you. However, I did mention in the beginning we would prioritize people who had not spoken. So Shayla Lewandowski and Paul Lott is on deck.
Thank you for staying so long, everybody.
Good evening, you guys. All right, so I have two simple questions.
Yes.
One, the second question, I'm kind of surprised nobody's asked yet, but my first one is, I'm sure y'all have heard me say how I'm intersex. So how does this law protect me?
Yes.
Because I had an employer refuse to hire me because they said I was radically transgender, when in reality I'm intersex.
In this law, under the definition of gender identity, it specifically says intersex. Okay. In the definition. Intersex for everybody means that a person who has biological aspects and components like DNA or chromosomes of both sexes.
I'm double X, double Y.
There you go, double X, double Y. And this is not something that somebody chooses. It is a absolutely biological circumstance. It's one of the problems with people saying, well, we're going to designate either you're a girl or a boy, because when people are intersex, how do you choose that?
Well, actually, can I add to that really quick?
Sure.
So I just want to say, because I don't think many people know this, I'm going to be 37 this year. When I was 34, I got really sick, couldn't figure out why. Went to the doctor, they sent me for a whole slew of tests. That's how I found out I was intersex. Mm-hmm. So it wasn't like one day I woke up and I felt this way. I was literally dying. Yeah. So that's why I wanted to
I was looking at the number of students you have in schools in Luzerne County. It's about 43,000. And among that, based on statistics, it would be likely that 96 of those children would be intersex.
Yes, and I do remember reading somewhere that prior to the 90s that there was surgeon, what the hell do you call it? Gynecologists would actually just pick a sex for the child.
Right.
So that may be what happened. But now on to my second question.
Go ahead. Go ahead quick, because your time's running out.
Is there any religion exception for churches that don't agree with LGBT or any parts?
Absolutely. Absolutely. Any church that can follow the tenets of its church 100%. And this is in the exemption section, so let me explain this really clearly. Mission-driven organizations, any mission-driven organizations, it could be the Boy Scouts, it could be the Knights of Columbus, it could be who follow Catholic tenets, any church, synagogue, following the mission, the tenets of their mission. If they're following the tenets of their mission, here's an example. If you're going to hire a priest, they can say the priest has to be Catholic, and he has to be a man, and he can't be married, and he can't be gay. And all of those are the tenets of the Catholic Church. And they're absolutely allowed to do that, because they're following their mission. Those are the tenets of the Catholic Church. But they can't say, and by the way, the person that mows the lawn also has to be Catholic, and they have to be not married, or they have to be not married, and they have to be a man. You can't do that, because that has nothing to do with the mission of the Catholic Church. That is specifically in the exemption section of the ordinance, and it's very, very specific with regard, and I was asked this by county council people too here, very specific to one organization like the Girl Scouts, for example, who say that people who participate in the Girl Scouts have to identify as not male. They have to identify as something other than a boy. And if they do that, they can be part of the Girl Scouts. And they're allowed to do that because the traditional circumstance of the Girl Scouts, their mission is to promote the health and welfare of girls. And they're allowed to. There you go. Thank you for asking that. I'm glad I got to say that.
Of course, I appreciate your answer. As a matter of fact, my church, I won't say what church it is, but the priest actually, when I told him my story, even though it's a Catholic church, he told me I'm still welcome to be there as I am and however I am. So just wanted to ask that question so everybody can have that answer. Thank you.
You're welcome.
That's very nice to hear. Paul Watt and Mary Ann Pottsville, you are on deck.
So this question regards section 304.1 unlawful accommodations.
Okay.
I know it was stated previously. Okay, so Title IX, under the Biden administration, they expanded the definition of gender.
Yes.
A lot of people think Trump turned that around. There's actually, in Tennessee versus Cardone, that was reversed and vacated by the court.
Okay.
So that under Title IX, male and female can be enforced as biological. It doesn't have to be the expanded definition. That was also just affirmed by the Supreme Court July 8th of this year.
Okay.
That wasn't case. That wasn't fact. That, for the sake of Title IX, that they go by the definition that was used in 1972 when the law was passed.
Okay.
Okay. So in this provision, in 304A, would this allow someone who wanted to go, a guy or a girl wanted to go into the opposite restroom, would they be able to file a discrimination suit, given that Title IX at the federal level defines biological sex as the basis for the separation of the facility? That's the first question. The second question is that talked about that Pennsylvania law is what it is, but with this Supreme Court ruling just this month, that would, wilkes-barre, Luzerne County has a workaround where they have male, female, and if you want to, under the privacy laws of Pennsylvania, you have to give them a private place, address, et cetera, et cetera.
Okay.
I guess my question is, could someone bring a suit using this provision, a complaint using this provision, given the fact that the expansion of Title IX in schools was reversed?
Who would they bring the suit against? Which are you talking specifically about?
Tennessee versus Cardone.
Yeah, that was a Tennessee case, but go ahead. What was
it? Was overturned federally. I mean, you can check the case.
Okay, it was overturned federally.
And the Supreme Court affirmed it, so I think the Supreme Court is the law of the land. Therefore,
Okay, but I don't fully understand your question. What are you asking now? Let me answer the first question. Okay, can you read that? Let me say this. The numbers in the Lehigh County law are different than the numbers in the Luzerne County law. So could you read me that section?
This is the ordinance. Okay.
This is copyrighted.
The following actions are prohibited. A person or organization may not refuse, withhold from, or deny any person because of protected class, either directly or indirectly, any of the accommodations, advantages, facilities, services, or privileges of such a place of public accommodation, resort, or amusement.
So this is a public accommodation circumstance.
Public school.
So you're asking for, no, that's not, education is separate from public accommodation.
So the answer is no.
In this particular session, the question is, and I fully understand your question, you're saying that if somebody could bring a lawsuit because they wanted to use the restroom?
No, could a transgender student bring a complaint
Yeah.
before the commission
Yeah.
because they want to use the facilities that they identify as the gender they identify as? Or does this not apply?
I think that a transgender student who would be denied resources in a school district might be able to bring a suit, yes.
Based on, even though it's contrary to federal law in Title IX?
Yep.
Okay, all right, that's a problem. One last question. You were mistaken when you said that it never happened that a transgender student didn't switch back and forth.
No, I didn't say that.
Yeah, you
I didn't say
did.
that. I said it doesn't happen very much, but I said, what I did say was, if you have somebody who is, if you imagine or you have somebody in your life that you've met that's fluid, do we really want to say nobody else should be protected from discrimination because one time I came in contact with a transgender fluid student?
The Loudoun County superintendent was brought up on charges in Virginia.
Oh, I know this Loudoun County.
You know the case.
Yes, and it has been misrepresented so many times.
It was in my school district.
Okay,
I know
but I know what happened in that
Just
case.
so you know, your
I was there.
time did end.
Okay, well, I read all about this case.
Read about
and
it. I was there.
Okay,
I
so
was
what
there.
happened in it?
What happened is the gentleman said that he was transgender.
The boy,
The boy.
and he met up with a girl and had sex with her in the bathroom. That was the end of the story.
That wasn't the end of the story. The reason why the superintendent was prosecuted is that he put on a skirt, he raped the girl, the school system was told.
No, that's not what
Rather than
happened.
prosecute
I've
him,
researched that,
he
and
was
that's not what
transferred to a
happened.
This is not a debate, Mr. Lott, and your time is up. I would also like to note that the Title IX decision was only held to sports, and also Cardona was not held on the merits.
There you go. I do want to say that
That's fine.
I have had other people bring up that Loudoun County case, and that is not what happened. What happened was two kids were in the bathroom, and what happened was a boy and a girl met up in the bathroom to have sex. They'd done it in the past. And the boy said he was gender neutral, but he was in the bathroom with the girl. They had met up to do that. And she, during this sexual encounter, said, no, I don't want to do this. And he forced her. That has nothing to do with being transgender. Nothing. And somebody, I was doing a training when somebody said this, and I said, look, people don't rape people because they're transgender. They rape people because they're criminals, and they're not protected by law. Certainly not this law.
Protected by the school.
They're not protected by the school.
He was.
Councilwoman Smith, who's up next for the question?
Thank you, Councilwoman Stephenson. Mary Ann Potsko, you are off, and Walter Griffith, the inevitable Walter Griffith, it seems like we will end like we started, is on deck.
Okay. I would just like to say, first of all, Mary Lott did an excellent job in describing exactly the way I feel, and I know so many other people feel. And this gentleman, I think, that was standing here was disrespected because he was in the school district. He knew the facts. He lived through it. And I don't think what you did was right or respectful to that gentleman.
Well,
it really upsets me.
I've also
We're
just
not
making
having
my
a
statement.
debate here, so
Yeah,
ask your
no,
questions.
Yes, but let
You
me
are on
just say,
thin ice.
let me just say, you had in this article, and there was no rebuttal to it,
Quiet, the peanut
Council
gallery.
had to redo the original county ethics code because attorneys argued that the county's ethics commission cannot legally serve as prosecutor, jury, and judge by handling both the investigation and adjudication of complaints. As a result, council revamped the ethics code to have a rotating panel of outside enforcement attorneys handle the preliminary investigation and, if warranted, prosecute the case before the commission. County Ethics Commission attorneys are paid $225 per hour with an annual cap of $25,000. Is this a lie or is this true?
This is the ACE, that is the ACE Commission, the Accountability, Conduct, and Ethics Commission. That is something completely different than this.
So this is not going to intertwine with the Human Relations Commission?
No.
So why was this even put out there with this? Why was this in the article?
I have no idea.
I don't. But I'd also like to note, when you bring something before this body, the HRC, it's not a lawsuit. And as Liz has mentioned many times, most of the time it's mediation. And there are other civil remedies that people can go for if they want, but this is not a lawsuit.
Right.
Just to be clear, so we're not using attorneys here. The ACE Commission does. There's a big difference there.
Well, I can only go by the article as I read it, and
And
it
we've
just
been
sounded
telling you
very-
the article,
No, there was
unfortunately,
no
is
rebuttal
wrong.
to it, there was nothing, it was let stand just the way it was. But I would just also like to say, if somebody does bring a complaint, and somebody does feel that it's not proper, they're going to get legal, they're going to have to pay for legal representation, it's going to cost them money. And I just think that, as Mary Lott said, which I give her all the credit in the world for, this should be voted on. This should be something the people decide, not just this council. It should go by the people, because it's going to affect everybody in Luzerne County.
I respect your opinion, but I'd like to also mention that in the court system, it is the same way. In the Court of Common Pleas, if a plaintiff loses and they feel that they should have won, they can appeal the case, but they have to pay for it. And then if they disagree with the Superior Court, then they can apply for writ of certiorari to the Supreme Court, or aliquot, it's in aliquot in Pennsylvania. But that's exactly how it is. That is how the system works.
But you are not a court of law. You don't have
Right.
that right.
We're not the court of law. That's the point of helping here, trying to mediate things.
So that it doesn't go to the court.
Next.
You don't want it to go to the court.
Walter Griffin. And Mr. Griffin, I'm going to ask you too. This is not a debate. Let's not talk over each other. Let's try to do better this time.
Okay, I'll do better. I'll try.
You can do that.
Well, my first question, and bear with me as I read the section for Liz, because she does not have our sections, but maybe you can jump in and follow along. My first question is, did the Office of Law approve this ordinance, and why if they did not? You can answer that later. But I want to drill down on the source of income issue, because I know Mr. Fry brought it up, and it's an issue for me that I've been speaking about as well when I'm getting signatures, is the source of income definitions. If you look at 20130, which defines what a bank is, and also 20146, which defines what a source of income is.
Yeah.
And just bear with me as I get to 20146, because that's the meat of what I want to talk about. 20146. 20130 talks about what a lending institution is, which is a bank, and goes on to say that.
Right.
20146 deals with source of income. Any lawful source of income, including, but not limited to, earned income, child support, alimony, insurance and pension proceeds, unemployment insurance, Social Security, and all forms of public assistance, including Social Security disability insurance. That's the definition of what income is.
Right.
Am I correct?
No, that's the definition of sources of income that you cannot say no to.
So that's not a source of income. What that's defining here is not your source. Is your source of income?
That defines the groups of sources of incomes that a landlord cannot deny if they are, if the tenant says, I have one of these sources of income, and it demonstrates that I can pay my rent for a certain amount of time, then therefore, the landlord can't say, I'm not okay with you using that source of income.
Okay. Okay. So when we jump into 303, which is the issue that I think Mr. Fry raised as well as other folks as well, it says, It says refuse to lend money whether or not secured by a mortgage in section C. That does not say that the bank does not have the right to ask you your source of income to loan you money.
This has to do with lending institutions discriminating against people based on protected class.
And protected class is source of income.
No, protected source of income is the definition, in that, what you just read is the definition of the sources of income that a landlord cannot deny. And your question is, when you're talking about the bank, these are definitions, but when you're talking about the bank, that comes under the circumstances of lending institutions, and this actually comes under housing because it has to do with lending institutions that allow you to get a mortgage or other kinds of circumstances like that. And banks are not allowed to discriminate against people based on their protected class status.
Right, but source of income is a protected class, is it not, in our definitions of protected classes? That is a protected class. Source of income.
Only for rental, not for bank, not for loans, as far as I'm understanding it.
So if we look, if you look at the definition of protected classes, which is in section 201, it says a protected class is source of income, which means that a source of income is a protected class. It cannot ask you your source of income. Is that my understanding?
No. You can ask the source of income. You just can't say no to protected sources of income.
Right, to legal sources of income.
Okay.
Walter, can I give you an example?
Yep, go ahead.
This is actually something that I have lived. I have a friend who is an independent contractor and is the major breadwinner in her home. When she applied for a mortgage, the bank just did not include her income at all because she's an independent contractor and only went with her husband because he had salary. And that greatly made it lopsided what they could afford. Is that? No, I'm not gonna.
And I think that's the problem that we have with the verbiage that's in this.
No, I think that what people need to understand is that when you're talking about lending institutions, you can't discriminate. A lending institution themselves cannot say, yeah, we're not, and this happened to my spouse, we're not lending you money because you're a woman. And that happened to her in the 1970s when she was going to buy a house. They said to her, you have to have your father sign the loan. And so she moved to another bank, and the woman who was running that loan agency said, you are the first woman who has ever been able to get a loan from this bank because, without having a man co-sign for it, even though her father had no money. And I'm proud that I am following the requirements of non-discrimination now in the late 1970s based on sex. I'm not going to discriminate against you because you're a woman. She had a really good job. So she was denied that loan until she found a bank that would give it to her. But now that's completely illegal to say, we're not going to give you this money because you're a woman. That's ridiculous.
So the definition of protected class is not the way we interpret it. That is not.
Not the way you're interpreting it, no.
That's the way it's written, and that's what we're assuming, because of a protected class refused to sell, lease, or finance. So that's the interpretation.
Well, that's what you're interpreting.
Right.
It's
So
not
the
correct.
landlord can say, do you have a job? And you say, you can't ask me that.
Mr. Goodwin, time, so please finish your thought.
Yep.
Okay. That is the last slip. I'm just going to make sure I'm not missing anyone. I would like to thank everyone for their respect. I know we came into this with a little worry, and there are a lot of opinions. Thank you for being here. Does anyone else want to make a comment? Okay, thank you. Thank you for everyone.
Anybody who wants to sign the petition, I got a call.
If people are misrepresenting it, don't forget they can be sued.
While some of the things are still up, I just want to mention, under our own charter and state laws, each petition circulator has to swear that each signatory understands what they have signed. And if that is not true, the petition circulator has broken the law. And I'd also like to note that I'd like to clear up some petition issues. Under the charter does not address referendum petitions. Under state law, all petitions, including referendum petitions, follow the laws of nomination petitions. Those provide that all petitions are to be placed online to the extent of the challenge period. When the challenge period closes, they are taken down. So hopefully in the future, Luzerne County will follow those laws. Secondly, prior to tonight, our Office of Law had been contacted by a few people requesting to remove their name from this ordinance, or I'm sorry, from this petition that has been circulating. Now that all the questions have been answered and the facts are out there, if you signed the repeal or ballot petition and you would like to remove your name, you can complete the form that is on that table there. It is available at the front table online via the QR code, or you can fill it out and return it via the directions. You certainly do not have to. You certainly have a right to sign this petition, but you do also have a right to remove your name if you'd like. Thank you very much.
I'm sorry, one question I may have missed when I went to see Walter left. So,
Don't say his name twice.
I won't.
No.
It's like that here.
Ask it quick, because we all want to go home.
You can, yeah, you can go.
So, he misrepresenting what he said here is that he's telling people that the protected class accounts for the house banking, which is untrue. Is that what I heard him say?
I'm not quite sure what he was saying, but he said something about banks and source of income.
I tie the housing income to the bank income and they're.
Yeah, well, let me just say that there's nothing in this ordinance that says that banks can't ask you about your money, and there's nothing in this ordinance that forces people not to ask what a landlord, keeps a landlord from asking about their income with regard to renting an apartment. And if people are telling you that, it's not true. That's all there is to it.